So I'm back. I'm going to try again.
All right.
On the share screen. Let's see. Now I cannot find the box link. Mr. Gilbreth, can you please pull up P18?
Yep. And while I do that, let me say for the record, so as far as Ms. Stinson's testimony and an offer of 18, for the record, the objection is that, what was my objection? That the pretrial disclosure was not made of Ms. Stinson as a witness or an expert, and the fees were not produced 30 days out from trial, which as I read the current disclosures, the suit was filed in 2021, so that be required. It does not specifically exempt enforcement actions under the family code. That's the objection, but then let me share the screen.
And Judge, I don't think that applies to enforcement actions, but Mr. Gilbreth didn't file a disclosure either, so, or pretrials for that matter.
I'm not filing. My only response to that, I'm not calling any witnesses or presenting any evidence other than my client, but I understand Ms. Stinson's point.
All right.
Okay, Judge. So this is.
Well, hold on. Can I get a ruling on the objection?
Oh,
that's an objection to what?
Ms. Stinson testifying and
Oh, to
presenting
her
expert testimony.
testifying at all. All right.
Okay.
So here's the thing about these new disclosures is I think everybody's just starting to get used to them. And I think in part, family lawyers may want to reach agreements on them up front about whether and when, et cetera. I don't know if they apply to enforcements or not. I haven't had that question come up, but they are new enough that I think I'm going to grant some leeway on it, but I'm going to suggest to y'all that in the future, you really do need to be looking at those and determining whether or not they apply. So I'm going to overrule the objection this time, and I'm going to allow Ms. Stinson to testify. I'll tell you, Ms. Stinson, here's what I'm concerned about. So if you could focus on this so we can finish this up pretty soon. You've agreed to a new trial that indicates some reason for me to believe that the first trial shouldn't have gone forward because the return was not on file 10 days in advance, which indicates to me that that responsibility for fees should not be on Mr. Guevara. I think absolutely you should get fees under the contractual provisions in the divorce decree for what it took for you to get those signed agreements. But I'm a little bit troubled with the idea that you should get fees for preparing for and attending a hearing that ultimately you agreed for a new trial on. And
Judge, in response, I would just point out that when we look at page 9 of the decree, which is exhibit 3, there is no caveat in there about, it says specifically all other costs incurred seeking enforcement of any of these provisions. And so I don't think that Dr. Keene should be penalized for this gamesmanship.
Well, let me just put it this way. I think that I'm only authorized generally under the law to award reasonable and necessary attorney's fees. And so the question is, were those necessary? Did you need to show up for a hearing if the proper notice had not been given and or the return of service wasn't on file timely? And so that's the avenue, I think, through which all attorneys' fees are awarded. Mr. Gilbreth has stipulated that your rates are reasonable and customary, and I accept that stipulation. The only question then is the hours, and I heard Mr. Gilbreth expressed concern that he could not really tell what hours he might object to because the bills are so heavily redacted. So,
And if Mr. Gilbert will scroll through them, it's the typical redaction we do, but Your Honor, as I mentioned previously, I am happy to provide you in camera unredacted so you can see them.
well, this is the last of this matter, so I guess I'm wondering why we need redactions at all. If y'all were getting ready for a final trial and you had secret work product included in your bills, I would totally understand why you want to redact them, but I'm not sure why they need to be redacted at all if this is the final hearing on this issue and your strategy isn't something that needs to be shielded from discovery.
That's typically
Well,
how,
it-
that
go
is
ahead.
typically how we present them, but I don't have any issue with replacing P18 with an unredacted version.
I think that would
Well,
be helpful.
I guess if I could respond to that, first of all, I don't agree that's typical. I actually don't redact my bills for this very reason, because I can't tell review redacted is pertaining to what? Review redacted, conference redacted. I can't tell what that is. And the purpose of the invoices is because the recent Supreme Court case, which we all know is, it's the Ramos case, ROHRMOOS, which is 578 Southwest 3D 469, talks about you don't get to get up there and just sort of globally say these are what my attorney's fees are. You have to break it down, particularly because you can't blend, right? You can't blend your fees with something that could be something that's not recoverable for fees. And the Supreme Court says, the best way to do that is to have your invoices. But I can't, not with these invoices. So Ms. Stinson saying, well, I'll replace it. Well, but I can't cross-examine on that, right? And I can't cross-examine on this exhibit the way it is. And so it doesn't give the court the information it needs to see what was done, and doesn't give me an opportunity to cross-examine on it.
Well, Mr. Gilbert still would have the opportunity to cross-examine. I mean, I'm happy to give them to him in a second. And then they're just not that long and not that complicated to look through, but I'm happy to give him a moment to do that if Your Honor would agree.
So,
I mean, I guess I'll say it kind of highlights the pretrial problem, right? I mean, if these are produced 30 days out, then I can look at them, prepare cross-examination. Hey, this wasn't about the passport. Hey, this was post. I mean, they're asking, it'd be one thing if they're coming here and saying, look, Judge, $5,983. They're asking for $14,000. That feels like more of a, I mean, that's a lot of money, right? And so.
So let me just say this. I agree that Mr. Gilbreth should have an opportunity to review the bills and to cross-examine Ms. Stinson about them, and or to make argument about why certain portions of them should not be awarded. It's 10 o'clock. We had talked about that this hearing would likely be over by now so that we could go on to our next hearing. Here's what I'm going to suggest, and it's dependent on y'all being available later today. We could come back to you all after the end of this next hearing. And in the meantime, Ms. Stinson, you could send him your bills, your invoices. Are y'all available this afternoon, let's say at 3:30?
Stop sharing, look at my screen.
Yeah, Judge, I am available. I would need to talk, I think, Dr. Keene.
I'm available.
Okay.
I'll make myself available.
I'll have to move some stuff. I mean, and alternatively, of course, not to put Ms. Stinson on the spot, but if we want to do it by submission, I can just make my points, which
And
I don't think will
that's
be
fine
many.
with me too. I'm gonna suggest that you all chat. We can move you to a breakout room if you'd like, or y'all can just log out and talk on the phone, whichever you prefer. to either come up with a schedule by which you'll look at their bills and have your opportunity to cross-examine and make argument from them, or you'll do the remainder of this by submission. Whichever you agree to, but absent an agreement, I will plan to see you back here at 3:30 and with no more than 30 minutes more and hopefully less than that. Of course, you're also not precluded from reaching an agreement on what the right amount should be. And if you can work that out, that would be great. But in the meantime, I do need to go on to the next hearing. And so I'm not ending this hearing, I'm just suspending it until 3:30. Okay.
Thank you, Judge.
All right. Thank you all.
Thank you.
All right. We are back on the record in the Guevara case. And I believe Ms. Stinson was going to provide unredacted attorney's fees bills to Mr. Gilbreth. And so, Mr. Gilbreth, do you have any questions for Ms. Stinson about those bills?
I could actually do it more. It's not really a question for her. It's more just argument pointing out things. So I don't have any questions. I have a highlighted version that I'll offer in my case, but that's it. But she doesn't need, I think she still needs to offer it, if I remember.
All right. So Ms. Stinson.
Judge, I would offer petitioner's exhibit. Well, first I was going to offer P18 because it has a summary. The back of it has the redacted bills, but just the summary on P18. And then I would offer P19, which are the unredacted bills. And then there's also a P20. That's the bill that just went out while we were on break. And so that's the most recent bill. That's August 15th through August 31st.
It just so I don't be deemed to have waived, because I objected to Ms. Stinson testifying the same objection that was overruled before, which is that they weren't produced 30 days out under the initial required disclosures or under the initial disclosures.
All right. And I am going to overrule that objection. And there is a grace period on those relatively new rules, but it will expire pretty soon. So I think everybody's going to have to get up to speed on that. All right. So P18, P19, and P20 are admitted. Did you want to say anything else about those, Ms. Stinson?
Yes, Judge, I did. This is, I will say, this is an unusual case in that in all my years of practice, this is the first time that I've actually had to file a motion for enforcement and go to court to get someone to sign the passport forms. And so I wanted to give you a history about why the fees are what they are. I will tell you that Dr. Keene asked me to try to resolve this every which way besides going to court. She asked me to contact Mr. Gilbreth at the start before we did anything. I did that. We sent a letter to Mr. Guevara first saying, please do this. Usually that does the trick. It did not in this case. So we filed our motion at the beginning of March. We had to get a show cause order for that. Mr. Guevara lives in Victoria. So we had to try and get him served in Victoria. And I would ask the court to take judicial notice of the file as well. We had to try.
Yes, the court takes judicial notice of the file.
Thank you. So I had an opportunity to go back through here. I mean, we had to get substituted service because the process server tried to serve him 6 times, left his card, all those things, never got any contact. So then we got the substituted service. I will note that Mr. Guevara did have 10 days notice of the hearing because we were dealing with a process server from out of town that we don't typically deal with. It took us a while to get the return back. And so the technicality on the motion for new trial was that the return of service was not on file for 10 days, but Mr. Guevara had 10 days notice of the hearing. And so we were actually shocked when he did not appear at the hearing and it was a default. No one was, Dr. Keene and I were not expecting that at all. So we had to prepare for that hearing. We attended that hearing, a default. There was a lot of work with the court to get the order signed. I was trying to look through my records during the break, and I noted that on all the communications from the court, Mr. Bovara was copied. And I went back through to count how many communications there were from the initial Zoom setting, information being sent out, then we sent exhibits, the court ruling, back and forth with the court about what they wanted to do, then they revised the ruling. We had to follow up with the court a couple of times. And then the court signed the order, but then they gave him additional time, 2 weeks after that. So he had until May 12th to comply. And then when he didn't comply by the 12th, we emailed the court again to say he had not complied. And that's when the court was working on a capias. And that response was on May 17th. But I counted all these emails that Mr. Bovara was copied on, and there were 11 emails with him and the court that he was copied on. And prior to that, he also had the letter from us, he had the show cause. And it wasn't until shortly thereafter when the court was about to issue the capias that Mr. Gilbreth entered an appearance. And I had talked to Mr. Gilbreth before we did this, and it's my understanding he reached out to his client. His client didn't want to move forward with him at that time. And so there was a lot in there. The technicality on the motion for a new trial. We did have to look at that. We did some research on that because frankly, we don't do a lot of default judgments in family law. You know, as the court knows, under the law, you just can't take a default very quickly in a divorce. It has to be on file for 61 days. So we did eventually agree to the motion for a new trial. You know, I did reach out to Mr. Gilbreth again at the end of June to say, look, these are what her fees are. It's just going to get more expensive. We'd just like to get this resolved and have him, you know, pay those fees. It did take the 2 weeks of back and forth to get the documents signed once we heard they were going to get signed. And then we had to get a new show cause order, get that served. Mr. Gilbreth did agree to accept service on that, but we still had to get it served. And then again, prepare for this hearing. You know, and I reached out again to Mr. Gilbreth before this hearing last week to see where we are. You know, and I didn't really get a response to anything until this morning. So I will agree that the amount is unusual, but all of the fees in this case were reasonable. And it was a reasonable amount of time for the work that was required to be done.
All right. Thank you, Ms. Stinson. Mr.
Thank you,
Gilbreth.
Judge.
I guess let me ask through Ms. Stinson rather than just calling myself to testify. You'll agree, Ms. Stinson, showing, and I guess you're on, I would offer, I would upload a Respondent's Exhibit 2, which is just Ms. Stinson's bill, but has my notation, a couple of notations on it. So I'd offer just to show Dad's response on some of these.
Any objection?
No, I don't have any objection.
All right. Respondent's Exhibit 2 is admitted.
And so just making sure my math was right, up until the morning, the day before the hearing, the default, the fees incurred were $5,143.94.
That looks about accurate because the fees at the time of the default were $5,983.
Yeah. And the default, this bill, this last bill, double check me if I'm poli-sci major, but I added them up. But this last bill was issued on April 16th, right? And goes through April 15th as the last day of the billing, correct?
That looks correct, yes.
Okay, and then April 16th was the actual day, correct?
Yeah, the date of the hearing, yes.
And so your fees exhibit captures all the time, even including the default hearing that was improperly granted by the and the order that was improperly granted, and deal with the motion for new trial. All that's captured in the bills after page 11 of your exhibit, correct?
Dealing with the motion for new trial, yes, that was after, well, yes, that didn't happen until May.
And also captured in your global testimony on fees, not only is dealing with the motion for new trial, is the back and forth with Mr. Guevara complying and trying to get y'all the passport, correct?
Yes, in June
In
2021.
But that's captured in your fees, in your fee testimony, correct?
It is correct.
And the divorce decree as well. I'll just make that point myself. Oh, to be clear, I think you said, I reached out to Mr. Gilbreth, who called his client. I think the more accurate statement is before filing, you reached out to me to see if I was representing Mr. Guevara, correct?
Sure. Yeah, that's correct. And I think you said you weren't representing him, and then we even had, you emailed us and said, here you go if the court needs anything.
Yeah, I appreciate that. And all that back and forth, all the show cause, the having to get alternative service, all that is captured in the $5,143.94 that was incurred before the hearing in front of the court on April 16th, correct?
That is the total amount of time up until April 15th.
I'll pass the witness.
All right. Ms. Stinson, anything else you want to add?
I think just briefly, Judge, I would like to say, you know, we did have the amount of the fees on for the hearing. He has it up until April 15th. Then at the hearing, it was $5,983. And that was what was awarded in Judge Cantu Hexel's order. And then also, I just wanted to point out to the court for the email that was previously admitted that I sent to Mr. Gilbreth on June 30th, that amount was $9,815.33 at that time. And that was, at that point, was when we finally had the signed documents.
All right. So, Mr. Gilbreth, I am concerned that your client made this so much more difficult than it needed to be. And I don't understand why. And the order, the decree clearly states that he is to sign them when presented within 10 days. And if he doesn't, then attorney's fees are going to be assessed. So what do you?
Your Honor.
So Mr. Gilbreth, I'm going to let you decide if you want your client to address me.
Yeah, and he did want, because he did want to explain the default and just briefly explain. But to be clear, I mean, the divorce decree says within 10 days. We're not contesting that, right? I mean, there's, you know, and the way I understand Ms. Stinson's presentation is they're not asking for contempt. I think if they're asking for contempt, then the court would take into consideration, you know, the behavior and the attitude, and whether or not there's intentional disrespect to the court. I understood from what she told the court this morning, they're asking that the remaining issues, attorney's fees. But he did want to address it if that issue is still out there.
All right. Mr. Guevara,
Yes, ma'am.
did you want to say something?
Yes, ma'am. Ms. Stimpson said that I did not reach out to the individual that was trying to knock on the door to leave me the paperwork. My daughter contacted him because I asked April to contact him because I didn't want to give him COVID. I was really, really sick. And after that, after she contacted him, basically,
I'm going to object to the hearsay.
it's not hearsay. I did it.
All right. So The objection is to you're repeating what anyone else said.
Oh, okay,
so
I'm sorry.
You may continue,
Okay,
but just don't talk about what anybody else said.
okay, and basically, after that, he never did show up. And basically a lot of the stuff that's going, I mean, that, and me and Jenny had already agreed that I was going to sign this back in November or whatever. And I was going to sign it, and there was no disrespect toward the court of me not showing up on that day. I was really sick. I could not breathe. I have asthma. I have a heart condition, and my physician sent a letter informing the courts that I was sick and that there was no way I was able to zoom in even that day because of my asthmatic conditions. But the one thing also is that there's been a little frustration with me because I have not seen my girl since December the 28th.
Objection, Judge, objection, relevance.
Well, I'm trying to understand why it is this became so difficult and took so long and ran up so much attorney's fees on the part of your client. So I do want to hear Mr. Guevara's explanation on that. So part of your explanation is you were sick. How long were you sick?
I was out of work for 6 weeks, and it still took me another 4 or 5 weeks to even get my energy back from the COVID. And Jennifer did know that I had COVID.
Objection calls for speculation.
All right, and how did you let her know that?
I called her about and let her know that I was gonna let the girls know that I had COVID. So the girls were calling me, checking on me as well. That'd be Macy and Kate.
Did you say Kate or Katie?
Kate, I'm sorry, Kate.
All right. And is there anything else you wanted to add?
Yeah, yes, in part, and a lot of this I think would have worked out. Like I said, I have not been able to see the girls since the 28th of December.
Objection, Judge, relevance.
Jenny has not brought them to me. She says it's their decision whether they come and see me or
Judge,
not.
I would object to this testimony. It's not relevant.
Sustained. So you can talk to Mr. Gilbreth about this, but if you have some complaints about violations of court orders, that's something that your lawyer and you will be able to deal with in another hearing, but it's really not part of this hearing.
Yes, ma'am.
But in any event, is there anything else you want me to know about why you didn't sign these forms when you were presented with them?
Yeah, a lot of the on the email stuff, and in terms of the email, I get they probably sent those emails are probably sent to my email, which I don't have anymore. Everything goes to Victoria Counseling Services, my business, and Jenny did send me something and that was the one I signed, the very first one I signed that wasn't that was in 2019 when she sent that one, but I never got another one in for the 2020 or whatever, because it was a new form at that point. But nothing that I did was out of district. I wasn't trying to be disrespectful to the courts or anybody.
All right, Mr. Gilbreth, anything else?
No, ma'am.
So what is it that you think is the correct amount of fees that were actually incurred in order to get these papers signed?
Right. If you look at, if I could just share a screen really quick. So pre-hearing, I do think it's reasonable for Ms. Stinson to say, and it's a lot, right? Spending $5,143.94 to get a passport signed. But if you look at her bills, she had to go down, she had to get a show cause order, She had to do that multiple times. So I think that's, I mean, I stipulate to the reasonableness of her rates and fees. That's the amount before the hearing, before the court. I think it's up to you whether or not, you include the time going to court. So it'd be 51:43.94, or if you include the time that she went to court, then it'd be the amount that was in the prior order. As I review the bills going on past that hearing, it's dealing with motion for new trials, it's dealing with correspondence for me, and it's dealing with compliance, not non-compliance. It's dealing with compliance of us saying, yeah, we're gonna, because if you look at the exhibits, they email and say, actually, we need his driver's license. Oh, okay, we'll get you his driver's license. They hadn't asked that before. You can see that in the email. Here it is. No, we need the original. Okay, here it is. Here's the original. We're FedExing copies of the original documents. That's all having to do with compliance. The divorce decree, the contract these folks signed, had to deal with non-compliance. If somebody writes my lawyer and writes the other side's lawyer and says, we need the passport form, and the other lawyer writes it back, that's not under the divorce decree something that's recoverable. That's something that's compliance with the order. That's just the logistics. And the way Ms. Stinson presented her fees is she hasn't really segregated them. And the case, you have to segregate your fees if you're, when you're baked into what you can and you can't recover. That's Tony Golo Motors, 212 Southwest 3D 299. If you don't segregate, so everything post. If you look at the Ms. Stinson's exhibits, everything post everything post either $5,143.94 or the amount through the hearing. Everything post that is mixed in with compliance, mixed in with new trial, and she didn't segregate in her testimony. And even just looking at my markup, you can't tell what it is. So that's a long answer to the court's question, which is, I believe it's $5,143.94 if you do it before the actual trial. And then if it's through the trial, then it's the amount that's in the prior order.
All right.
Judge,
And Ms.
sorry.
Stinson.
I did want to point out, just so we can clarify something, we are asking for contempt because I just didn't think there was any dispute that he was in contempt. He was to sign the paperwork within 10 days, and we didn't get it until June. So, and I would say in response, Judge, all of the fees go back to the motion for enforcement, which she's entitled to all of those fees under the decree. I just don't, Mr. Guevara was contacted so many times about this. He certainly had the opportunity to reach out to anyone, the court, myself, and say he couldn't appear, he needed it to be reset because of COVID. And of course.
Well, and so are you saying that your client didn't know that he had COVID at that time?
I am saying that, and I'd be happy to recall Dr. King, because what he said is not my recollection of our understanding of what happened at all. And if you would like me to, I'm happy to call her on rebuttal.
All right. Briefly, very briefly. And Ms. Keene, I just want to know whether and when you knew he had COVID.
I knew he had COVID after our hearing. And that night that I called him of our hearing, that I think it was on a Friday that we saw Judge Hexel Cantu, I called him that night. And that night he told me that he had COVID. But prior to that, I did not know that he had COVID.
All right. And you hadn't talked to him recently?
No, ma'am.
And your daughters weren't aware of it?
No, ma'am.
And Judge, just one follow-up question. Dr. King, did you ask him to sign that paperwork at that time when you talked to him?
I did. I asked him to sign the paperwork. I told him that I asked where why, if he knew that he had missed a court hearing, and he said that he did know that he missed a court hearing, that he had COVID. And then I told him what had happened and that I would appreciate it if he didn't go to jail, because I would not like to have to explain that to our daughters. And that's when he told me he didn't have to sign the paperwork and he was not paying attorney's fees. So
Judge, I pass the witness.
Anything further, Mr. Gilbert?
You're on mute, Mr. Gilbert.
Yeah,
You're-
I got it. Thank you.
You're on.
So, thank you, Vidal. I got it. With regards to the, let me just pull up one. And Dr. King, the order, to be clear, nobody contacted the court and said, the default order that we just took, the respondent was sick with COVID, correct?
Mr. Gilbert, that's not mine to do. Like, do you want me to call them on a Friday night to tell him he had COVID? Like, the fact of the matter is he's a grown man and he should have taken care of that. So no, it's not
Right.
my thing to say that he had COVID. We already had
And
an
the,
order.
right. And the order was signed by Judge Cantor. The hearing was on April 16th. The order wasn't signed till April 30th, correct?
I don't know when the order was signed.
And the order agreeing to the motion to new trial wasn't agreed to until 2 days before the hearing on the motion for new trial, correct?
I'm not sure about the dates.
Nothing further.
All right, well. So here's the thing. I don't excuse Mr. Guevara's behavior in failing and refusing to sign the order despite many, many requests. It's clear to me there did need to be a motion and a hearing. It's unclear to me how much of the other fees since the date of that motion and hearing were made necessary by his behavior as opposed to being made necessary by the fact that there was what we're calling a technical issue with the return of service not having been on file for 10 days. I don't think he should be tagged for that part of it. And so I also don't think he should be tagged for the cost of the new trial, which isn't to say he shouldn't be tagged for everything, including this hearing, but not that hearing, if that makes sense. And some of the work that you had to do that was made necessary by his behavior, as opposed to just the failure to have the return of service on file 10 days in advance. All of that is my way of saying I think I need to look through the invoices myself, because I think that the right amount is something more than the $5,143.94. I don't know how much more, and I don't think it should be everything that's been incurred up until this moment. But in saying that, I do not excuse his behavior. His behavior was wrongful. He should have signed this. It was called for by the decree. It was agreed to, and he does need to pay some attorney's fees. So I'm going to look at the attorney's fees bills and come up with what I think is the right amount of attorney's fees to award against him. Now, as to whether to find that he was in contempt or not for failure to sign these forms, kind of depends on what I think and whether I believe this COVID excuse. I'm kind of inclined to say you're going to have to pay attorney's fees, but I'm not going to hold you in contempt this time, but I am going to make it a note in the file that I'm concerned that the conduct came awfully close to contempt. And I just don't feel like I have a good enough handle on the timeline to know for sure about that. So there's an order out there. Y'all need to follow that order. This is just one of the things about that order that needs to be followed. If there are some other things that are out there that are not being complied with, then I would request that y'all work on complying with it or reaching some new agreement. That said, I will make a decision as quickly as I can after looking at these invoices and order that these attorneys' fees be paid by a date certain. When are you asking that they be paid, Ms. Stinson?
You're on mute.
Sorry. We submitted a proposed order and we had left that date blank. I mean, 30 days is sufficient. I did want to point out one thing on the contempt issue, Judge. We had introduced Exhibit P12, which was an email that Dr. Keene sent to Mr. Guevara asking him to sign the passport forms back in November of 2020. His testimony was that he had COVID in March of 2021. So that would not have prohibited from signing the forms. That's well past the 10 days. That was just one of the first times. Well, actually not even one of the first times, but that was one of the other times she had asked him to sign the forms.
All right, well, let me say this. I have, and the court reporter may have something different, but I have that, yeah, P1 through 17 were admitted.
And 18 through
And
20.
18 through 20, okay. I just want to make sure that I had all of those. So I will take a look at 12. And is the proposed order in box?
It is in box under the other materials.
Great, I will take a look at that as well. And I thank y'all for your time, and I will get you a decision as quickly as I can.